So you'll have to execute me or whatever and send me to my angels, and I'll be back in 3 days, and we'll just see what happens.
All right, we'll go on.
He starts the hearing talking about martyrdom, execution, even resurrection. It's less a defense and more a theatrical act. Right away, the judge steps in, trying to steady the room before it spirals.
He's still seeking a continuance of the upcoming trial?
Yeah, I have had no access to evidence. James R. Watts played a trick. He brought a phone number by me, and he knows dang well that arms list won't answer a collect call. I wanted addresses and phone numbers. Now, the phone numbers, if I went to Larned, I could use those up there. But anyway, I can't use them here. But anyway, I've had no access to get anything. Nothing's changed since the continuance was granted last time. I haven't even got glasses, can't see. And then they've also been refusing medical. The dizziness and stuff from the negative energy being inflicted to me is getting worse. But anyway, no, I have not got access to anything. I haven't even got the transcript. I wanted a copy of the transcript to go over. I need a copy of my grandfather's will. All firearms were left to me. So Dad saying that firearms on there were left to him. No, and all those firearms are newer than could possibly be left on that will.
This is where it really unravels. He bounces from legal points to health problems, then veers off into inheritance squabbles. The judge keeps trying to bring him back on track, but it's like chasing smoke. And beneath it all, there's a hint of sadness. He's clearly overwhelmed, yet instead of focusing, he sinks deeper into conspiracy and family drama.
But stuff has been asked for.
Right. Let me address Attorney Watts. Attorney Watts, do you have any knowledge about this will?
I would not, Your Honor. I would note that Mr. Watts has a subpoena power. He would have the ability to request a subpoena, and I'm certain that as he's acting pro se, if he would request a subpoena from the court would be glad to grant that. He could subpoena that will and send that subpoena to his parents or his parents' attorney. And under that subpoena power, they would have the obligation to provide that document if they have it. He has subpoena power for bank records. He has subpoena power for any of these documents he wishes. He simply has to issue the appropriate subpoena.
I'll try that then. I'll get busy and try to subpoena stuff. But
Defendant Watts, the court doesn't have the authority to order your parents to produce this will. That's something that they can either hand over to you voluntarily or not. But I can't order them to produce the will.
So that's denying me evidence. I mean, if you get a court case going where everybody has the evidence as witnesses against you and they don't want to do it, that's not anything by God at all. No, you get all
as Attorney Watts stated, if you issue a proper subpoena, that may be an avenue from which you could obtain this will. But barring that, I don't have the authority to order your parents to produce this will. I'm going to take up another motion that you filed. This one's titled Motion to Take Notice that Attorney James R. Watts visited me at the jail October 10th, 2024, Thursday around 2:15 p.m. and only left a phone number.
What makes this moment striking is the judge offering him a lifeline. Use subpoena power, the tool every self-represented defendant has. But he doesn't want procedure. He wants shortcuts, demanding the court compel his parents directly. When he frames it as denying me evidence, you can hear his paranoia colliding head-on with the rules.
Myself, I don't trust this James R. Watts attorney at all. You know as well as I do in the Bible, attorneys are the worst, evilest, and wickedest there are. They always trick, fool, deceive. I've had no luck with attorneys. I had them up at Chase County allow lies to put me in jail or prison for a couple of years. They aren't worth a damn.
All right, well,
Then the gloves come off. It's not just distrust of lawyers anymore. He paints them as the worst, the most evil, the wickedest of all. You can sense the court's patience wearing thin, yet they let him run. The judge seems to know that pushing back would only feed the fire.
At least $100 billion every word. And it's going to be paid in gold at $5 an ounce. Laugh that up. I determine what the price of gold is. And my cases from Chase County and Butler County before are still going on. They're tripling. Damages are tripling per day. They don't triple every day, but there's damages every day. It's add up every day.
What evidence are you claiming you have not been provided?
I purchased all those dang firearms through my phones, off arms list, and there was only one or two I purchased out of the Wichita Eagle. That bull barrel AR-15 in 2006 probably is probably in there, or might be the first of 2007. That bull barrel AR-15 DPMS was purchased out of the Wichita paper. They would have access to that ad. The rest of them were purchased through arms list. I'm not worried about purchasing firearms. You know as well as I do, there are no laws limiting felons from firearms. In the 1930s, they established a National Firearms Act. When the United States went bankrupt, the bankers made them do that. That's stupid bullshit.
Well, Mr. Watts, what evidence?
I never will not have firearms. And I'm having machine guns. Two of those were fully automatics. I'm not dealing with this at all. So you'll have to execute me or whatever and send me to my angels, and I'll be back in 3 days, and we'll just...
This is where it boils over. He goes from bragging about buying machine guns to declaring laws don't apply to him, then circles back to his resurrection threat. It's not a defense, it's open defiance, almost a dare to the court. By now, it's clear he doesn't see the system as having any authority over him, and that's a dangerous place to be.
Expensive. If you have the funds to pay for a transcript, you can obtain those, but they're just not produced for free and given out.
They were at Chase County on my cases up there. I absolutely received preliminary hearing transcripts without paying for them or so on and so forth.
Well, this was a case in which you were present at the preliminary hearing. There are circumstances in which the court will order that a transcript be produced, but it has to be paid for. And if you have the funds to pay for the transcript and want to get it, that's up to you. But I'm not going to order that it be produced, as it was a hearing that you were present at.
Yeah, but I need it in case people are going to commit perjury or lie, whatever. So I'll have it, and I need to go through it and just see whether it gets transcribed properly.
That brings us back to the motion to continue the trial, and I'm not inclined to grant the continuance of the trial. This case has been ongoing now for a very long time. I think it's the oldest case that I've got on my docket, and it needs to be tried.
We'll be going for jury nullification. I have that right. You're just playing around. I told you before when you did this continuance, I went and get my evidence, and you said we would address the motions later. Now you aren't giving me the time to...
We're addressing your motions, Mr. Watts.
Okay, I can't do the subpoenas in the time you're giving me now.
Well, I'm not at this time continuing the trial. We've got another court date, a pretrial conference scheduled. I believe that is January 31st at 9 o'clock. Jury trial is scheduled to begin February the 4th.
Your Honor, if I may,
Go ahead.
I've mentioned this to Mr. Watts before. If Mr. Watts would provide me, either by letter or I can come out the jail, a specific list of who he wants to subpoena and what documents he seeks, I can put those subpoenas in the appropriate form and send them out.
You wouldn't get around to them right away, probably.
Well, if you could get to that sooner rather than later, Attorney Watts, that would be appreciated.
I'd like to know also, I forgot to mention, I'd like to know the cost of the transcript too, for that preliminary hearing.
Judge, I have no idea what the cost is. Typically, they're $200 to $400. It depends on the length of the hearing, of course, but I really don't know what it would cost.
Now, my parents, they'll refuse to give me the money to get that, and I have money coming in. So what do I do in that situation?
Well, I think maybe we can look and see how much it would.
And then comes the crash. The judge draws the line. No more delays. The trial is happening. He pivots to jury nullification, essentially begging the jury to ignore the law. That's not strategy, that's desperation. It leaves a stark image, a man caught between his own unshakable beliefs and a justice system that refuses to bend to chaos.